Bonjour and welcome back. We will, in the next 4 videos, discuss rights in a civil law context. And the first distinction that I will present is a very generic one between patrimonial and extra-patrimonial rights, a rather mysterious terminology, but we will try to make sense of it. Here is a comparative overview of rights featuring rights or interests, as they are called, in the common law and in the civil law. You see on the left side that the common law tends to discuss and categorize interest in personality, in property, and in relations. Wherever the common law is discussing interest in personality, the civil law categorizes those rights as extra-patrimonial. Why do we call them extra-patrimonial? It is because they are not to be regarded as entries in your patrimony. Remember that the patrimony is the balance sheet of your assets and liability. Remember that every person, be it a natural person or a juridical person, has one patrimony that is regrouping all assets this person has at any point in time and all liabilities. Uh, so rights that can be regarded as entry in the patrimony are called extra patrimonial rights, okay, and that includes property and obligations that will be discussed further down the road. But we have a number of rights that do not fit as entries in your patrimonies. And I'm going to give as an example um, your voting right, because this is, at least in 2020, an election year. Can you put a dollar amount on your voting right? That right would be categorized in the common law as an interest in personality that includes political rights, right that you may or may not have regarding your privacy, the protection of your honor, all things that you cannot designate as entry in a patrimony. It cannot be regarded as assets, though you have them. You cannot transfer actually your voting right. It's deeply personal. It is your right as a citizen. And you cannot put a dollar value. Of course, you may get damages or compensation in case you are deprived of the possibility to vote. Imagine that some militia is assaulting you when you are trying, to cast your vote. You may have a court action and you may obtain compensation, but this compensation is not going to reflect the dollar value of your voting right, but the amount of damage, personal injury, and possibly also emotional loss that you suffer because you are deprived of exerting your right as a citizen. So this is what is distinguishing what is within the patrimony and has a dollar value and what is outside the patrimony, extra patrimonial. We will discuss these extra patrimonial rights with more detail in a moment. Let's get now into patrimonial rights, things that are actually entries in your patrimony. And here you find in the civil law distinction between real rights that deal with property and personal rights that deal with obligation. The common law would categorize them as interest in property and interest in relations. Note that you don't have this phraseology of extra-patrimonial and patrimonial in the common law because this is a concept that the common law is not using. You may say the common law doesn't use it. maybe the concept has no value. Well, you will see that distinguishing extra-patrimonial and patrimonial rights helps us in the civil law systems to map out the rights that you have and understand what legal regime they may be subjected to. So let us discuss first, in very general terms, those patrimonial rights, which are those that are easier to grasp. They are, as I indicated, susceptible of pecuniary evaluation. They are part of a person's patrimony. For each patrimonial right, you see an entry in the patrimony. And as a rule, patrimonial rights are transferable inter vivos. What does that mix of English and Latin mean? That means you may transfer those rights to other living person as long as you are alive. You own a car, you want to sell it, you transfer actually ownership in this car to another person. The fact that you sell your car creates, you had an asset, the ownership right that you have in your car, you are going to transfer it into another type of asset, the personal right to recover the price that is promised by the buyer and the legal action that you may have against the buyer to get the value, the agreed value of the car. These patrimonial rights are also heritable. You can inherit them from people when you're provided, of course, that you are the heir of such person or that you are mentioned in their will. You have few exceptions to the transferability of patrimonial rights. Sometimes some obligations are strictly personal. Like the position that I have in the law school, okay, being a law professor at this great law school, which gives me, of course, a right to collect a salary at the end of the month. That right is strictly personal. If I happen to die while still being on that position, my son or my daughter cannot claim that they inherit my title as a professor and collect the salary. Mind you, that was possible, under feudal law in Ancien Régime France, where you were inheriting positions as judges in the old parliament, but that's not the case, you see. My obligation to perform my duties at the law school are personal. It's me based on my academic profile and credentials and experience and nobody else. But this is exceptional because generally speaking, all the patrimonial rights can be freely transferred to whomever you want. I may assign the copyrights that I receive on some of my publication to my spouse or to my children, or even give them to one of you to help you fund your legal studies. You won't go very far with this because professors do not collect much in terms of royalties on their publications. We do not sell our books by the millions of copies. So indeed, in the economy, we are constantly trading patrimonial rights, and we will study them with more detail in other videos. Let us get now at the more complicated part, the extra-patrimonial rights. I gave you the example of voting rights that I'm not going to discuss it. Okay, what these rights have in common, and that applies, by the way, to the voting right, extra-patrimonial, extra means that it is outside the patrimony. You cannot fit those rights into the patrimony. They are non-patrimonial rights, if you prefer to put it that way, that do not qualify as assets or liability. They are not transferable. They are not heritable. The moment your professor becomes a US citizen and has the right to vote at election, my son who lives in Ecuador is not going to inherit my right to vote at a US election. That doesn't work that way. This right is deeply personal. It's not subject to prescription. A citizen who spends all her life or his life without casting a vote at some election is not losing the right to vote by prescription. These are rights that you keep anyway. That doesn't mean to say that the action to vindicate these rights does not prescribe. There may be a limitation to exert that action, but the right itself remains with you as long as you are the holder of such rights. So they already have this very, very particular nature of being deeply connected to the person to who you are, rather than entries in your patrimony that come and go depending on your spending or your ability to acquire and develop your patrimony. So these extra patrimonial rights include, I could have mentioned political rights, but we are discussing civil code subject, and voting rights are not discussed in the civil codes. But what you will find typically in a civil code are family rights and what we call personality rights. So let us explore these rights. And first, the family rights. These family rights actually connect to the moral character of the family relation. Not so much the financial aspects of it, but see, the right for an alleged father to recognize a child. By the way, if you are married to the mother, there is no such need to recognize the child, because by law, there is an article in the code that says that the husband, whomever is the husband, at the time of birth or even of conception, is presumed to be the father of the child. But if the child is born out of wedlock, whomever thinks or has strong reasons to believe that he is the father can recognize the child. Put a dollar amount. Of course, it's going to generate liabilities, and these liabilities may qualify as personal right, but the right itself to establish a family relationship with this child has no dollar value in itself and is extra patrimonial. The same can be said of parental authority that parents exert on their children. Uh, this is a purely moral right. It includes, of course, duties and obligation to educate the child, to make sure that the child is fed, dressed according to the season, etc. Uh, but there is something that is intrinsically moral in its nature. It includes the respect that is owed by the child to the parent, and conversely, the parent to the child, the right to correct the child when the child is doing something that is wrong. It includes also the right to visit the child after divorce if the parent is losing the custody of the child. All these rights cannot be described as entry in the patrimony. They remain with the parent, even if the parent is neglecting the child during a long period of time. You don't lose this right or this relationship by non-usage. You may be taken with remorse and decide to reestablish a connection anytime in your life. Okay, all this is not patrimonial. Okay, this is more dealing with care, respect, love, though love is not a legal concept. Law cannot go that far into human relationships, but the law pretty much organizes and tries to define what parental relationships are from a legal point of view. Okay, and it includes, yes, some rights that nobody is going to challenge, even, well, except if you're educating and correcting the child is making you a perpetrator of some crime, okay, by injuring the child or etc., criminal law may take care of it. A part of family law, the child code, will protect children against abuses by parents. But again, we're not discussing assets and liability as they are understood in the stuff of patrimonial rights. Okay, these family rights have or may have a patrimonial content. Okay, some patrimonial content may develop as a consequence, like the mutual right of support that spouses have towards each other, or the right to alimony that an abandoned spouse may have against the other spouse, or likewise, this right to alimony may exist in parental relationship. Parents may owe alimony to children in need, and children may owe alimony to their parents. You may say that the patrimonial aspect is the sort of accessory to the principal right, which is extra-patrimonial in nature. And I come now to personality rights, which, as the name indicates, are deeply connected to whom you are, to your person. And that include, and by the way, when we talk about personality rights, they have developed in the context of natural person. And there is a debate at present whether this right could be extended to juridical persons. We may discuss that, but that would take us pretty far from the mere categorization of rights. So the right that you have as an individual, as a natural person, to your physical and moral integrity is typically described as extra-patrimonial, though, of course, there will be patrimonial consequences in case of infringement, such as by a tort. The right that we may have over your name, if you are a natural person, this right in the traditional civil law analysis is regarded as extra-patrimonial because you cannot sell, I cannot tell to any one of you, okay, I'm selling you for a royalty of $1,000 a year, the right to be called Olivier Moreteau, which may help you in some of your life. The name itself is not a commodity that can be sold that way, which doesn't mean that you cannot make deals about the name, but these deals, by the way, are more typically done about business names, names of juridical persons, okay, or legal entities. The right to privacy, which is very, very controversial and is protected very differently depending on legal system. I come from a country, France, that cares a lot about privacy and considers that anyone, whether you are famous, infamous, or totally anonymous, you can vindicate, your right to privacy, and which means that media have to get your consent before they publish things about your liaison, sexual life, or anything intimate, about you. It's not so in the United States. The right to privacy is a lot weaker in our system, and Louisiana tends to follow mainstream American attitude in that regard. But, I cannot tell that my privacy is worth millions because I'm vindicating all the time or less. It's not an entry in my patrimony. Though undoubtedly, if a person, is challenged in privacy right and vindicates it all the time, that person may get higher damages than people who do not care and all at a sudden have a fit and decide enough and enough and want their privacy to be protected. Are also part of these personality rights, and that may be a little bit more tricky to grasp, but that's very civilian in perspective. We consider in the civil law that whatever you produce with your intellect, be it art, literature, movies, music, you name it, that the author has a patrimonial right, a copyright, which is intellectual property, though that right, that part is clearly patrimonial and is an asset in your patrimony. But there is also a moral right, which is extra-patrimonial, and under the law of all European countries, at least on the continent, you may actually object a wrongful use of your artistic creation. We have cases of painters who have made a big painting that would be as large or larger than the tapestry that is behind me, and decide, oh, I'm going to cut it and make it two distinct paintings. The painter may object to that, though the painter has sold the painting to you, but keeps a moral right and say, don't tamper with the integrity of my creation. I may oppose your making two or multiple painting or actually destroying my art. And we do not have this moral right in US law, but guess what? The US has signed an international convention, a Berne Convention, that protects copyright. And under that international convention, the copyright and the moral right are to be recognized, which means that the moral right, by the way of this international instrument, is part of our US law. So as a lawyer trained at LSU and hearing of this concept that develop in a civil law context, you may get an edge over people who get a totally common law education and are completely lost when they hear of moral right in the context of intellectual property transactions. That goes, just to give you a famous case, the owner of a movie that was shot by John Huston in black and white, I forgot the name of the movie, had been colorized down the road, to make it more appealing to the present public. And the author actually opposed this. I say, no, it is completely changing the nature of my movie. It has been conceived to be black and white. That is typically moral right stuff. And though the American party, the Hollywood party, knew nothing of moral right because the Berne Convention applied, a French court could impose the recognition of this moral right and ban the commercial diffusion of the movie with colors. It had to be presented in black and white only. So these rights, of course, can be protected by money awards, compensation if you tamper with them, damages for infringement of personality right, and indirectly that may lead to some form of commodification of the right of privacy, but that's a pretty sophisticated conversation that you will have the moment you specialize in the study of moral rights or rights of privacy. All this is fascinating because the line between what is patrimonial and extra-patrimonial is very clear at times and kind of blurred some other times. And by the way, this is so with all the categories that we have. You always have a gray zone, and the gray zone between category is the place where lawyers are making a living. Okay, so we don't want at all cost things to be clear. And yet, guess what? Whenever legislators or jurists are putting their mind at trying to have clear lines, there will always be pockets of uncertainty. You cannot avoid it. That's the nature of human affairs. I get now to patrimonial rights again, though we will discuss that with more detail in other videos. These patrimonial rights, I alluded to that already, have subcategories, real rights and personal rights. Let me introduce those. real rights belong to the law of property. They are rights that are exerted directly on a thing. Thing was called res in Latin, hence the word real. That's the tangible reality, what you can hold. And these rights are quite powerful because you may evict any person invading this right. You know, if you own a house, you can actually evict, you know, any trespasser. Um, or if your car is stolen, you can recover it. Okay, normally, no matter what, though there may be a few exceptions to protect people who buy then the car in good faith. You will study that with the law of sales. Uh, okay, we're talking about real right because the right is really in the thing itself. And by the way, you can enforce these rights against the whole world. Anyone trying to tamper with that right can be a defendant in the lawsuit. Personal rights belong to the law of obligations that you are also going to study next semester. How exciting. Next semester you'll study civil law property, all the stuff of real right, and the law of obligation, the stuff of personal rights. What I'm telling you is actually introductory material to the study of these two fundamental subjects that are regarded as the pillars of the civil law system. So in the law of obligation, we are dealing with rights a person has against another person. It's person to person, hence the name personal. Makes sense, right? You may demand performance of the personal right, but only from that person, not just anyone, okay? If the buyer of your car does not make the payment, you cannot ask your neighbor or your professor to make the payment instead, okay? It is a relationship between the seller and the buyer, and nobody else is interested in it. It's personal relationship, hence personal right or right in personam, if you love Latin. So they can be enforced only between the parties to a deal or the parties to the obligation. Another example that I could give, you are in an accident and which has been caused by the other party's negligence. You may sue the negligent party who has caused this damage, but you cannot sue the whole world or just anyone to get compensation simply because you are aggrieved or deprived of your little finger in that accident. No, it's only party to party. I'll give now an example of transactions that are very near to one another, and one may actually qualify as a real right and the other as a personal right. Uh, there are many different ways you can live in a house that does not belong to you if you are not the owner. You may benefit from a usufruct, and the usufructuary has the right in the enjoyment of the house. So you can stay and live in the house. Usufruct are typically a right that a surviving spouse, not inheriting the house belonging, to the deceased spouse, nonetheless keeps the right to keep living in the house under usufruct that will extinguish at the death of the surviving spouse. So that gives you the right to enjoy the house. If you can no longer live in the house but have to go to assisted living, you may cash the rent from that house, and you can actually enforce the right that you have to live in that place or get the income that that place may generate against anyone, against whomever the law calls naked owners, maybe they're your children, who will actually have the full value of the house after your death. They cannot temper or decide to kick you out of the house, okay? Or against a purchaser. If the children sell the title or the naked ownership, we will see that with more detail in another video, you can vindicate your right to stay in the house. You don't have to live because you have all your real right. The usufruct is your exclusive right to the enjoyment of that house as long as you live. The usufruct is a real right. If you live in the house under a lease because you are renting and paying rental, as a lessee or tenant, as we commonly say, you have a right against the owner, the lessor, okay? And the lessor has to leave you the exclusive enjoyment of the house. But this, in the civil law at least, this is a personal relationship. You can enforce that right only against the owner or the lessor. Imagine that the owner is selling the house where you live. The new purchaser may kick you out. You don't have a real right to the place. You may be very unhappy and sue the lessor because the lessor has to warrant, your peaceful enjoyment of the leased property and should not engage into any conduct that is causing you to be evicted. But that's your personal relation with the lessor, with the owner. You cannot resist the action by the third party buyer who wants you to get out and move your things out because they want to live in the property or let it to anybody they please. So the lease actually creates a personal right. So you see that with two situations where people may be allowed to occupy a house, you may have that right as a real right, which would be the case of a usufruct, or a personal right, that would be the case in a lease. Now, leasehold can be a leasehold estate in the common law regarded as a real right, but I'm not here to teach you the common law, okay? Here in Louisiana, leases are governed by the civil code and follow the civil law tradition and give you only a personal right. This brings us to the end of this video, and we will continue to study those patrimonial rights in the forthcoming videos. See you next time.